Hello, and welcome to our online What's New in Municipal Law 2021, presented by the Bureau of Municipal Finance Law of the Division of Local Services. Bureau staff will conduct this presentation, which, through narrated videos, will discuss recent cases related to municipal finance and municipal law. So let's get started.
Hello, everyone. I'm Don Gorton from the Bureau of Municipal Finance Law. I'll be presenting cases about property taxation and a case about zoning restrictions which bear on property value. The first case today is Murrow v. Boston Assessors. And this case is about a condominium parking easement held taxable as a present interest in real estate. Now, the ATB used its summary judgment procedure to decide this case. The rule is, Rule 22 of the ATB, issues sufficient in themselves to determine the decision of the board may be separately heard and disposed of in the discretion of the board. The board found no genuine issues of material fact, and assessors were entitled to judgment as a matter of law. The ATB rejected the taxpayer's argument that property taxes fell on the fee simple interest in the condominium, which would be the condominium unit owners. That argument was rejected. Next. Commissioner of Revenue's authorization to assess present interests in real estate is no longer required. That's a result of municipal modernization in 2016. So the ATB cited an appeals court opinion involving the same taxpayer, Cashin v. Murrow. Parking easements are not part of the condominium common area. The area in which parking easements are situated is part of limited common area, but excluded by the declarant from the provisions of Chapter 183A. Freely alienable easements in gross are separate from the unit owner's interests. Next. The appeals court rejected the argument that freely alienable, non-appurtenant parking easements are subject to tax as part of the common area. There's an appeals court case called Rousseau v. Assessors of Boston. Following the Rousseau precedent, the ATB ruled that parking easements are subject to taxation separate from the condo units. Now, the taxpayer held the full possessory rights in her parking space through the easement, including the right to exclude others who might be unit owners themselves. It would be an absurd result if unit owners with no interest or rights to use the parking space are taxed, while the easement owner enjoying the benefit of the parking space escapes taxation. So this case was decided for the assessors.